I'm also a member of the Elder Abuse Consultation Team in Toronto and have been so for over 15 years. I wanted to and was offered the opportunity to take the time to talk to you about how we can protect our seniors using the criminal justice system. I've got a PowerPoint presentation, which I'll share with you now, and I understand you'll get a copy of it later. I do invite questions, but as Laura said, perhaps what we can do is we can hold those off until afterwards, and we can get through those at that time. I'll just pause, and the screen should be sharing now. And of course, I'll just wait a second in case Laura decides to pop in and scream that you can't see it, but it looks like it's good. So, what are the concerns that a lot of service providers and family members may encounter when they're dealing with elder people and abuse? What is that we're talking about? For many, it's very evident. It's physical abuse, unwanted physical touching, whether that is striking the older person, grabbing them, or whether it's sexual in nature, touching them inappropriately. The abuse can also be non-touching, that is threats, verbal threats, threats to their safety, threats to their property. And it can also be thefts, whether it's taking an item, actually taking out that beautiful vase that mom has had in her front hall for years and years and years and just making off with it, or whether it's by fraud. Sadly, a lot of our elder people don't always have the mental ability that some of us younger people do, and they can be taken advantage of by scammers, also sometimes by trusted and dear friends and family. Those charges can include theft and also fraud and others. Those are all rather deliberate, intentional acts. There are sadly also things we need to protect our seniors from that aren't necessarily so deliberate, but they're not providing or not doing what one should. For instance, charges of failing to provide the necessaries of life or criminal negligence. Those two all require a duty, that is an obligation, something requiring the person to help the older person. One goes to the criminal code, and I always carry a copy of mine with me, you'll see section 215 talks about those duties that people have. Everyone is under a duty, if they're a parent or a foster parent or a guardian, to provide the necessaries of life for children under 16. Everyone is under a duty to provide the necessaries of life for a spouse or a common law partner. And everyone is required to provide the necessaries of life to anyone who is under their charge, who can't, because of their own circumstance, withdraw themselves from their care. That might be a police officer owes a duty of care to somebody in a detention center, or perhaps a doctor or a nurse in a hospital where the person is unable to leave themselves, or maybe your own mother and father, if they are confined to their home and rely on you to take care of them. What are we not talking about? We're not talking about just being plain nasty. We're not talking about being rude. We're not talking about just not helping out by raking the leaves around the house. I'll give you an example of this. Now, for those of you unfamiliar about criminal matters, what I've shown you here is the case of Siwicki, S-I-W-I-C-K-I. That's the last name of the defendant. The date and those MBCA and 104, those refer to the sites. You can all find this case. It's open and available to you. You can go to www.canlii.org. That's CANLII.org. This is a free and open site, and you can find this case there. Now, in Manitoba, as an example, the accused, Siwicki, lived with her 89-year-old mother. The mother fell out of bed, and the daughter didn't help at all. She got her water, she got her some Boost nutrient drink, but left her on the ground for 26 days until she died. The first responders, the EMS that came in, they found that the mother was covered with feces and urine. Her hair was matted, dirty, and sadly, she had several gaping and infected bed sores on her leg and hip. After death, the pathologist opined that the victim would have been in some pain for a period of time because of the infections, and her death was completely preventable. Sawicki was charged and ultimately pled guilty to criminal negligence causing death. She had that duty of care for the mother, and she didn't meet it. Now, the Court of Appeal in Manitoba increased the sentence originally put down by the sentencing judge and increased it to 2 years. One of the things that we're going to talk about today is how the court system can protect some of our elders. That 2-year mark is an interesting mark. When somebody is sentenced to more than 2 years, they go to the penitentiary. But it also means that the court cannot impose a probation order. Effectively, what that means is if the person gets parole early, let's say they spend 1 year of their 2 years in custody, the remaining year they are supervised by a parole officer. And so they'll be under the purview of the court for that remaining year. As a different example, if the person were to have been sentenced to 23 months, so not 2 years, the court could impose upon them a probation order of up to 3 years. And so even if the person is released from custody for good behavior, in that case, they still will be under the purview of the court and the review of the court for a further 3 years. It's an interesting difference between the two sentencing regimes, and you should just be aware of that when you're providing information to your clients about what may happen, whether somebody gets sentenced to the penitentiary or to a local jail. So, what can you do if you encounter a situation where you think that the person is being abused? Call the police. First and foremost, the police have very great resources in investigating, and their awareness of the effects and the prevalence of elder abuse has increased, certainly a great deal, in the last 15 years since I've been involved in the EAC team, the Elder Abuse Consultation Team. When the police are called, the first thing they'll do is investigate. The investigation will include interviewing witnesses. You might be a witness if you saw what happened or heard what happened. They'll gather evidence, new evidence that hasn't been there before. They might take photos, record statements, etc. And they'll also gather existing evidence. Maybe there are surveillance cameras, a nanny cam, something that may have caught what happened, text messages. Then the police will determine whether charges should be laid. When they do that, and if they do decide that charges should be laid, they will go before a jurist, a justice of the peace, and they will lay an information. That means they will start the criminal process by swearing before the justice of the peace that a crime has committed, and the charging document will then be created. If charges are laid, a charging document is created, then they will ensure that they arrest the person. Once that's happened, the police have two options about what they might do. They can release the person themselves, or they can hold the person for bail. If they release the person themselves, they are able to put on certain conditions on the person. The person would be released on an undertaking. That is the person's promise that they will follow these terms. The undertaking that the police release the person on does not have any surety requirement. That is, there is no person in the community, no friend, no family member monitoring this person to make sure they follow the conditions. Police use an undertaking, and the court requires them to use an undertaking when they have the defendant, that is the person charged, does not have a history of involvement with the criminal justice system and does not require more stringent conditions placed on them. The law requires that the police and prosecutors and judges ensure that as the person gets more involved in the criminal justice system, only then do they go up a ladder of increasingly more onerous restrictions on them. So the police may release somebody on an undertaking, And there will be conditions on that person, but they might also hold the person for bail. When the person's held for bail, they're actually brought before a jurist, and a decision has to be made. Should the person be released or not? Sometimes that's on the consent of the Crown, and the Crown agrees if the person agrees with certain conditions. And sometimes the Crown does not agree, and a contested hearing must be held. And then the jurist decides whether to release the person. Even in those cases, conditions will be placed on the person. But again, if they are at the lower end of the ladder, they may not have a surety in place for them. That may not be required, which again will mean there is no one in the community supervising them to ensure that they follow those conditions as a surety. What does that mean for you? If you hear, learn, find out that the person is breaching their conditions, call the police. Now, once the police do lay their charges, the person will be required to attend court. Hopefully they'll get a lawyer. And I say hopefully because one might think, oh, it's better if this person doesn't get a lawyer, the Crown will be able to do what they want with them. But that's simply not the case, nor should it be. The Crown Prosecution Service wants a fair approach to justice, as do judges and justices of the peace. Having a lawyer there for the defendant will ensure that they receive the proper counsel for them, the proper supervision for them in their criminal justice process. The difficulty is a lot of people don't have the ability or funds in order to hire a lawyer. In any case, all people are presumed innocent, and the defendant will then have an option as to whether they want to plead guilty and admit wrongdoing or have a trial. It's their perfect right to have a trial. Again, trials and guilty pleas are much assisted when the defendant has a lawyer. If the defendant chooses to plead guilty, or after trial, if they're found guilty by the judge may then impose upon them, as I discussed earlier, an order of probation, or if they sentence them to a longer period of custody to the penitentiary, then the parole service will take over. If a probation order is put in place, the judge can specify exactly what terms the person is to follow and how long the probation order can last. The maximum length of time that a probation order can last is 3 years. And the terms generally are required to be focused on the defendant's rehabilitation, but also the protection of the public. So having a term that the person have no contact with the victim or not be within a boundary area around that person, not to have any weapons, perhaps take counseling as directed by a probation officer, are all appropriate and usually included. If there are specific issues that need to be addressed, it's important, if you are assisting the complainant or the victim, that the police are made aware of that so they can liaise with the Crown and an appropriate determination made as to whether the condition that is sought can be included. Let me give you a little bit of a visual understanding of how this process happens. The process starts with the police and a complaint made to them. They make the investigation and determine whether an arrest should happen. The bail, whether it is an undertaking ultimately by the police or it is held for bail before a jurist, will usually contain conditions. That bail will end at the completion of the trial. And if the person is found not guilty, there will be no conditions on them going forward. But if they are found guilty, then the courts can impose a probation order on them. Let me give you an example. In case of Foubert, F-O-U-B-E-R-T, this is an Ontario court case. And in this case, the PSW was taking care of an elderly person who had Alzheimer's and dementia. Other workers were noticing that there were unexplained bruises on this resident. Co-workers of the PSW finally called police, And they had said and advised that they had seen this PSW roughly treating the residents, throwing the resident down and squeezing the resident's hands and kneeing them. As a result of that, the defendant was charged and ultimately pled guilty. There was a term of jail imposed of 8 months and also a probation order of 2 years in length. Now, the police don't always lay charges. Sometimes the police will investigate and determine for a variety of reasons that they don't believe that charges are necessary. Sometimes equally, people don't feel comfortable going to the police. Although I will say, at least in Toronto, the police are a very professional service. One of the things that the police do offer is an ability to do an investigation which the average person cannot do. However, whether the police have chosen not to lay charges or the complainant has chosen not to go to them, there is yet another venue for the person or anyone to get entry into the criminal justice system. Anyone can appear before a justice of the peace to either lay a charge or start the process for what's called a peace bond. Now, a lot of people talk about various restrictive orders of the court. Really only the two that we really need to talk about are probation orders and peace bonds. Excuse me. A peace bond is an order of the court, much in the same way that a probation order is. However, there, generally speaking, is no one supervising that order. That is, the court will make the order and, generally speaking, will rely upon the person to follow that order. Whereas a probation order always has a probation officer that is assigned to the matter. The person may not be required to report to the probation officer, but the probation officer is there in the background. So if a complainant goes to the police, doesn't get redress, doesn't get what they wish, they are able to go before a justice of the peace. Having gone before the justice of the peace, that justice will have to determine whether it is appropriate to have the information laid. That is, does whatever the complainant says actually make out an offense? Saying, well, my neighbor was talking badly to my mother, I want them charged, is not an offense. Saying my neighbor threatened my mother, threatened to kill my mother, is an offense. The justice will have to look at that and determine whether or not what is alleged actually constitutes a criminal offense. If it does, an information or the charging document will be created. Once that happens, the next step is the person has to go before a justice of the peace at a hearing. This is called a pre-enquête hearing. And this pre-enquête hearing occurs in court, and the Crown is able to attend as well. At that time, the complainant must also attend and give evidence as to why the defendant, alleged in this charge, should be required to attend court. If the justice is satisfied that the person should attend court, normally the justice will issue a summons. A summons has no restrictions on the person. The only requirement that a summons has is that the person must attend court. Whereas when the police arrest somebody and charge them and release them on an undertaking or hold them for bail, there are conditions. A summons has none of those. Again, once summons to the court, the defendant, we hope, will get a lawyer. Sadly, again, not all of them do. It's in their best interest that they get a lawyer, and it certainly is in the interest of justice that a lawyer is present for the defendant. Again, they are presumed innocent, but may choose to plead guilty to the charge, or if it's a peace bond, they may say they don't wish to contest the allegations and agree that they'll enter the peace bond. If they say, no, I did not do this, or no, I do not wish to enter the peace bond, then a hearing will be had. Whether it's a trial or a peace bond hearing, it's a hearing before a jurist. If they're found not guilty, or there is no cause why they should enter the peace bond, they're free to go. There'll be no restrictions on them. But again, just like in a police-laid charge, if the judge finds that the person has committed a criminal offense or that there is cause to require them to enter into a peace bond, the judge can order that the person enter either a probation order or the peace bond. And those can also, that is the peace bonds, can also have conditions. Conditions of no contact, conditions of not being within a boundary area around the complainant, conditions of not being able to possess weapons. Let me give you a similar type of example about how that plays out. For what we call a private complaint, that is a non-police complaint, the person will go and first have a hearing, which is the pre-enquête. The summons without conditions will be issued, and then a hearing will be had. Let me give you another example, very similar. This is the case of Taylor. Now, this is from the Ontario Court of Appeal. And again, like the other one, you can go to canley.org and you can certainly read all the details about this. But in this case, the defendant was a caregiver to an older woman and got that older woman to prepare her will and power of attorney in favor of the caregiver. The caregiver used the power of attorney and withdrew over $125,000 for her own personal desires and needs. She was ultimately charged with fraud over $5,000. She was convicted and sentenced to 21 months in jail and 2 years worth of probation and a restitution order. And you might inquire why 21 months, which is a bit of an odd number, not 24, which is 2 years, or 12 months, which is a year, or 18 months, which is a year and a half. One of the reasons perhaps the jurist was thinking about was that if the order is less than 2 years, then a term of probation can be instituted. Let me show you how all of these work together. On the left-hand side, you can see police-laid charges. And on the right-hand side, you can see private complaints or non-police laid charges. You can see the difference between the bail having conditions, whether that's an undertaking from the police officers or a bail in court, and a summons having no conditions. Now, after trial on a police-laid charge, sometimes, and that's why it's a dotted line, rarely, the judge can say, I'm not going to find you guilty of the charge, but I do find there is no reason why you should be in contact with this person. And in fact, this elderly person has reason to fear from you and may cause the defendant yet to enter into a peace bond. It does happen, not always, but it does. And in the privately laid complaints, if it is a charge, then ultimately that can end up after the trial, which I've listed as a hearing here, in a probation order. Or if the application was for a peace bond by the privately laid complainant, it can end up in a peace bond. Now, that's all fine and dandy to talk about these procedures and these orders. But what does that really mean for you once you get this? Both a peace bond and a probation order are orders of the court. Many people find that important and will respect that and obey them. Other people, they're just fancy pieces of paper. They've got restrictions on them, but they're just a piece of paper. The police can only enforce what they know about. So one of the things that's important for you as a caregiver for an older person is to ensure that you have access to the orders. And you certainly can get access to the orders through the court or the police if it's a police-laid charge. Having a copy of the peace bond or the probation order will be useful for you. While it's true that the police do have computer systems, and they're usually very good computer systems, the difficulty is sometimes things slip through the cracks. It's possible that the police may not have access, or the computer system may have crashed. Having a copy of the order is important when you call the police. It just makes your life a lot easier because you can say to the officers, see, here's the order. This person should not be next to my grandmother. Enforcement. You've got this fancy piece of paper now, this probation order, this peace bond. You found out that somebody is doing something improper. The probation order says, do not contact grandma. The peace bond says, don't be within 100 meters of grandma. But yet you see that person continuing to come back, returning back time and again. Call the police. Again, it's really important to call the police because the police can both investigate and enforce, but they only can do what they know about. Sometimes, in certain situations, the police may observe an incident happen, in which case, once they investigate the people and they find out the defendant is on a term of probation, and they say, but you're not supposed to be with that lady, that elderly lady, why are you with her? They can charge them. But a lot of offenses happen behind closed doors. A lot of offenses happen when the police aren't able to see what's happening. So they'll rely on you, the caregiver, the PSW, the family member, who can help them. You can help them with your eyes and your ears, what you see and hear. So when you see something that's breached, somebody doing something that's breaching one of those court orders, call the police. Explain to them that there is a court order in place, what the court order is, and what breach is happening. It's also important that it be done in a timely fashion. If you go to the police and say, 3 months ago, we got a probation order against the defendant, and the next day he contacted my grandmother and threatened her again, but we didn't call you, the police, for 3 more months. You might think about what the police are thinking is going on in your mind. Well, they didn't really care for 3 months to call about this. Must not have been a very serious issue. Oh, they waited 3 months. Maybe they have an ulterior motive now in calling the police. If this is an issue for you, if the fact that the person is breaching an order is of concern, call the police and do it right away. It both shows the immediacy and importance of your call, but also allows the police to gather the information that they need. Remember, there may be surveillance videos available, there may be text messages, other forms of documentary evidence. Some of those disappear after a period of time. Various video recorders record over after a week. Once that happens, the police cannot gather that information. So by acting expeditiously, by acting on time and quickly, it helps you help the police enforce the order. Give them all the information that you can and follow up on it. When they do get the information and when they do their investigation, they may then lay further charges. Those charges can include breaching a probation order and breaching a peace bond. When they do that, the same process will be engaged again. That is, a charging document or an information will be laid and the person will be arrested. They might be released by the police on an undertaking, or they may be held for bail. And again, it's equally possible that they may not be granted bail. While I spoke earlier about a ladder of increasing restrictions on people, once a person is out on charges, if they commit other charges while waiting for their determination, while waiting for their trial, they have an obligation to show why they should be released. It's called a reverse onus. Just going to stop the slideshow here. And so one of the things that's important is to give the police all that information and make sure that you follow up with them. The police system, sadly, is very busy nowadays. It's not inappropriate for you, having made the complaint, to get the name of the officer who is responding to the matter, and if you haven't heard anything in a reasonable time, to follow up with them. There also is a system called the Victim Witness Assistance Program. They are people at the ministry within the courthouse whose job it is to both assist victims and witnesses in the preparation and presentation of their material to court, and also to liaise with them to ensure that they are aware of what's happening and are kept up to date. If you want that information, make sure you touch base with the victim witness assistance worker, and usually they're able to help you. Now, a lot of people say, I want a restraining order. Well, in criminal law, we have these two processes that we can go through. They don't end in what's called a restraining order, but they are effectively restraining orders, either a probation order or a peace bond. Now, I do realize we're a little early on the time, but I wanted to give some time for questions. So perhaps what I'll do is I'll stop here and I'll throw it back to Laura, because I think she might have some questions that you've asked, and I'd be happy to answer them.
Absolutely. Thank you so much, Jason. I just kept thinking as you're presenting, I feel as though if you're not a lawyer or a police officer, that you're truly lifting this mysterious veil of what happens in or throughout the court process. So I want to thank you for lifting that veil so eloquently. We do have a couple excellent questions. So I'll start with the first one that came through. The question is read as, is the Crown obligated to defend the Canadian Charter of Rights and Freedoms and provincial human rights codes, affording individuals protection from age discrimination as well as elder abuse?
The Crown, and we're lawyers working for the Crown, we are obliged to both follow the law, but also do more than that. The Supreme Court has said that we are mini ministers of justice. Our obligation is not to seek a conviction. Our object is to ensure that justice is done. Justice can be done by seeking a conviction, but not always. And so we have an obligation to ensure that the process and the Charter of Rights and Freedoms dictate some of the rights that we have within this country is followed, and all other statutes are followed, but to ensure that at the end of the day, a fair and just outcome is done. That, as I said, does not always mean making sure that a conviction is the end of the day, but making sure justice is done. And I'll be honest with you, it's one of the things that I really enjoy about this job, is it affords me some creativity and some discretion about how the criminal justice case should go through the system. Sometimes it's appropriate that a matter gets diverted. Sometimes it's a learning experience for the person. Sometimes they can take some counseling or upfront programming, and the Crown will choose not to proceed with the charge. The cases that I've shown you today are ones where that would definitely not happen. There are egregious cases of terrible abuse, in which case the criminal justice system is appropriately engaged. But there are other times where the appropriateness of the ultimate disposition can be dealt with the Crown determining that a diversion is appropriate or not. And we also have an obligation to ensure not only that the public interest is taken into account, but also that we only continue prosecutions when we have a reasonable prospect of conviction. And so that ensures that we look at the facts of each case and say, do we have the facts that we can go before the judge and prove this case? And if we don't, sometimes that happens, we just don't have the evidence, we cannot continue the prosecution.
Excellent, Jason. So I asked in the chat box for some questions, and when you ask, you shall receive. So we have 10 questions sitting here to get through. So next question is, how do you get a copy of the probation order / peace bond? What information do you need to provide to the court?
All charges, as I talked about, have an information. All informations have an information number. Getting that information number assists you a lot. The police, when they create the charge, the information, will get that information number. If you're able to liaise with the police officer and get that information number, fantastic. Now, remember, the police are very busy, and getting that information number can be difficult from them. Getting it from the Victim Witness Assistance Program can also be a venue. And if you have an opportunity, perhaps in a prep meeting with the Crown, you can also ask them and they can give you that. There's nothing private at all about that information number. The last thing you can do, I think you can get this. You can go online to ontariocourtdates.ca. That's ontariocourtdates, plural.ca. And you'll find a list of everybody who's appearing in a court for that day. I think it actually includes the information number there as well, except for matters for which there is a publication ban. Sorry, and then once you get the information number, I should go on to say, then you can go to the court clerk more easily and ask if you can get a copy of it. I think there probably is a fee to be paid, of course, to get the copy of the information number. If you don't have the information number, you can still call the court clerk's office, and they should be able to assist you. It just becomes much more challenging if you have a common name like John Doe. Sadly, if you have a name like Jason Balgopal, there's only one in the world, and so they'll find that immediately.
Okay, here's a wonderful question from one of our community partners. So she's describing that she's working with a couple where the spouse has been assaulted by the other spouse. Charges have been laid and a no contact order has been put into place. The person charged is diagnosed with dementia. What, if anything, can be done by the family, community supports, and hospitals so this person doesn't have to go through the criminal court system? The spouse is the primary care provider. Spouse with charges may be advanced enough with dementia that capacity to understand and comprehend the situation could be questioned. Jason, your thoughts?
Well, I have to preface this, and in fairness, not trying to dodge anything, but I have to preface this by saying that I can't give legal advice. And I also have to follow the restrictions of the policy manual that it binds me, which means I have to consider both my audience, you people, but also my obligations. And my obligations as a Crown is I have to look, I'm the prosecution on this. But I can tell you, not on this specific one, but generally. But what I can tell you is how I as a Crown would look at this. And firstly, the best way to get movement on a case is to talk to the Crown. The most difficult thing to do in a criminal justice system matter is to talk to the Crown. So the best way of moving forward is to have a lawyer, because I can talk with a defense lawyer in a way that I certainly can't or would be unwilling to talk to a private complainant. Now, what moves the Crown is evidence. So the more evidence that counsel can provide to the Crown about what's actually happening, the better. The police certainly gather a large amount of it, but they only gather some of it sometimes. They don't always gather all of it. They may not know all of it, and the family may have more information. We have more information, doctor's reports about how dad has been, how the dementia is affecting dad, or what have you. The more evidence that counsel is able to provide to the Crown about what is happening on the ground allows the Crown to make a better and informed decision. That may mean that ultimately the matter is not fully prosecuted and a diversion is put in place. Maybe it means, don't know in this specific case, but maybe it means the Crown decides, all right, we will not proceed on this matter if the defendant enters into a peace bond. Okay, and what might that mean? Maybe that means that the two older people can't be together again unless there's somebody else there monitoring them. That's a creative thought I've just come up with. It could include a whole bunch of different conditions. Could be challenging conditions, could be simple conditions, but we're, as the Crown Prosecution Service, we're able to liaise with defense counsel and come up with a good solution to deal with this most of the time. Sometimes we definitely have to look at the safety of the complainant and say, what is necessary to ensure that this person is not seriously injured?
Okay, next question, Jason. So there's two questions I'm going to combine. A couple of people seem to want to know if, in particular, if Toronto Police have a dedicated elder abuse unit, and another question alludes to other police detachments across Ontario. Maybe you could speak to Toronto.
So at various times, I've been supported and have had communication with um, really great officers out of various divisions within the Toronto Police Service. I don't know that there is a dedicated service-wide unit dealing with elder abuse, but certainly within various districts, 4 district, 5 district, 1, 2, and various divisions, there have been in the past dedicated officers that deal with it, and they've been really good. Anytime I think you have people who have an interest and knowledge about a particular area, you often get a better result. Listen, I'm here because I'm interested in this area, not because I was told to be here. I had to fight actually to be on this panel. I had to do a lot of work to change my schedule to be here. So that just talks to the dedication and commitment. I do know that Waterloo has had, I don't know if they still do, a dedicated unit. And so I do know in other areas within the province, there are other jurisdictions that do have those units.
Absolutely, and really good point, Jason, is that there's a difference where you live in Ontario. So if you're living in OPP land, like I do, there is not dedicated officers throughout the province. But if you happen to be living where there's municipal police, there's more of a likelihood there may be a dedicated officer. Any one of you can reach out to our office. We do have connections with dedicated offices across Ontario, so we would be happy to answer those specific police questions around an elder abuse officer. So next question is, what happens if the victim of abuse does not want the perpetrator to be charged? They may be the principal provider for the care of the victim. Now what? What are the next steps?
Charges are not pressed by complainants. People often say, I don't want to press charges. And that's not the way the system works. The police have an overarching duty to protect and preserve life. And so they ultimately make a decision as to whether they will lay the charges or not. Once that happens, then it comes to our desk, and the Crown has to take a look at it to determine whether the prosecution is in the public's interest and whether we have a reasonable prospect of conviction. It's at that stage that we'll certainly take into consideration the wishes of the complainant. We have certain directives that we have to follow, and certainly domestic abuse has been an issue in the past and often continues to be, which is of great concern to many people for good reasons. The crimes that happen in a domestic situation are often hidden from the public. They are often occasioned in a situation of trust and confidence, and that trust and confidence is broken. The elder abuse situation often it happens in a situation where loving and trusting spouses get into conflict with each other because of dementia or Alzheimer's, and it's not the same person you were dealing with before. This has been a challenge for the criminal justice system, and I think it's going to continue to be a challenge as our population ages. It's one of the reasons that I'm interested and involved in this area. Having your voice or the family's voice heard is important. And again, there are three main ways that can be done. Certainly advise the police. I don't want this person charged, or I only want certain restrictions placed on this person. But know that the police have certain requirements themselves, and there are other venues. You certainly can have a conversation with the Victim Witness Assistance Program, and they can at least take down your concerns and assist in relaying them to the Crown, or talk to the defense lawyer. And the defense lawyer can relay those concerns to the Crown. And then the Crown will take those into consideration. It doesn't mean, though, the Crown is just going to say, oh, well, you don't want to prosecute. Well, then we'll stop. But it does mean that the Crown will take it into consideration about how the prosecution proceeds through the system.
Okay, so I'm going to amalgamate two questions in regards to peace bonds. So, part one of this question is, can you go anonymously to the justice of the peace to get a peace bond, especially because the accused lives in the same house as the victim? And is there a cost associated appearing before a JP to seek a peace bond?
No and no.
Okay.
So you can go to a justice of the peace, and you cannot be anonymous. In fact, as the complainant, your name will be written down there in the charging document. Laura Proctor feels that Jason Balgopal has assaulted her mother. There you go. Well, it's not quite too like that, but maybe a threat like that. When the charge is laid, however, that is done at an in-camera hearing before the justice. There's nobody there to hear what the person says to the justice of the peace. With the second step at the pre-enquête hearing, when it's determined, should we actually bring the person before the court? Again, nobody is there except the justice of the peace and the Crown. So are you anonymous? Well, no. But does anybody know this is happening? No. However, once the charge is laid and process is issued, that is the requirement to come to court, the summons, yeah, well, then the defendant will figure out who it is who laid the charge. Is there a cost for that? No, there is no cost for that, except there's a cost in time, because you, the complainant, if it's a privately laid complaint, not only have to go to the justice of the peace to lay the charge and to get process issued, you have to appear in court at each appearance. Because until the Crown attorneys take over the case, which they may or may not do, you are the prosecutor. And if you are not there when the matter is called, the justice of the peace may say, there's no official prosecutor on this charge, the matter is dismissed. So there is a fair amount of cost as far as time. At some point, the Crown may take over the prosecution of the matter, may look at it and say, oh, yeah, this is something we want to take over, in which case your obligation to attend each time is relieved. But until that time, you're spending time.
Okay, next question, Jason. They just keep coming in, so we're going to keep you till 3 o'clock. As a lawyer, you're going to like this evidence question. What can an individual do to build a case? So what kind of evidence should somebody start gathering to assist an abused senior?
Well, I think the first and most important thing is to protect yourself. Most of us don't have the training to be investigators. That's why police go to police college and take a lot of the training they do. Doing investigations can also place you in a situation of harm. The person catches you doing this, they may get angry or upset. And so I caution you all about how you go about doing this. At the same time, there's a lot of things that happen in life which you think nothing of, but are quite valuable. Maybe you're sending emails to somebody or texting them. Maybe somebody's left you a voicemail. Those can all be pieces of evidence. Keeping those is important. It's not, despite our digital world, it's not easy to go and gather them from other locations. Yeah, the police can sometimes go and get emails from your Hotmail account or your Outlook account. But it's far easier if you have a copy of that email right then and there, you can just forward to the police officer. So keeping what you have is the first thing I would say. As far as gathering extra evidence, it really depends on the case. Let me put it from my personal point of view. My father-in-law, before he passed, he had Alzheimer's. And while we never got into a situation where we felt we needed to have a nanny cam because we felt confident in the homes in which he was housed, it was something we did discuss. Now, you'll have to be careful about that, because while the person you're concerned about, your father, your mother, your whoever you may be trying to protect, those cameras may also intrude onto the privacy of the PSW. So you may think, oh, well, I'm doing nothing wrong, but you may run afoul of some privacy law. So it may be a situation where you, if you want to do that, you let the home or the long-term care facility know, listen, maybe the executive director or something like that. I'm concerned about this. I'm going to do this, X, Y, Z. And that's the other thing. Letting the home or the long-term care facility know that you've got concerns is important, because they also have the ability to put in place restrictions on people who goes into your parents' room or what have you, and may also say, oh, okay, well, we'll make note of that, and we have cameras in the hallway. We'll start recording those, etc. We are guided a lot by the physical evidence that we have nowadays. But a person's observations are still very valuable in court. If you see something happen, that is evidence. So having it recorded separately is very valuable, but your own observations are equally valuable too, and don't discount them.
So Constable McCabe has chimed in from our earlier question. So I just want to clarify that there is no dedicated elder abuse unit for Toronto Police. Detectives within each division investigate the cases. Toronto Police has a vulnerable persons coordinator who provides direction if needed, which is Constable Mark McCabe. So thank you, Mark. I appreciate you chiming in. And this is why I love doing live webinars, because we get to hear real-time feedback, which is nice. So this leads nicely into the next question. I'm not going to get in depth with the case that the individual provided, but the gist of the question is a crime had taken place numerous years ago. Is it ever too late to go to police and make a statement?
No, no, but there's a practical and a legal implication about that. The practical is just the human thing. He told me some bad words 5 years ago, or he said he'd shoot me up 5 years ago. Certainly is a crime, but you waited on it 5 years. Unless there's a really good reason why you waited on it 5 years, people are going to start scratching their head and say, well, how much are you really scared of this person if you waited 5 years? The other thing is a legal process. There are two ways in which matters can go through the criminal justice system. One is a summary conviction process, and one is one by indictment. The process going by indictment allows the defendant an opportunity for extra hearings and a jury trial. And it's because of that that the Crown will often very seriously look at whether or not they should proceed by indictment, because access to the jury system, it's very difficult sometimes. The resources aren't there. Whereas if we proceed by summary conviction, the person has no right to get a jury trial. And so they'll appear in provincial court and they can have a trial. Why do I highlight this difference? Because there's a limitation period. And if a matter is not pursued or charges aren't laid within 1 year of the date of the offense, the only way the Crown can proceed, pretty much, is by indictment. So, can you complain years later? Absolutely. Do we get complaints years later? Absolutely. Most of those are sexual assault offenses. Somebody sexually assaulted me many years ago, and it's taken me a long time to get over that trauma to finally complain. That makes sense as far as a logical story. Nobody's scratching their head, and the Crown will proceed on that by way of indictment, opening up the route to a jury trial, and that's okay. But somebody took my dad's book from his shelf 5 years ago. Probably the Crown's going to be scratching their head. They're not going to proceed by indictment for a stolen book. And so is there a limitation period? Yeah, there is. But it just kind of depends on the facts and the charge.
Next question, Jason. What are the conditions you would consider diverting a case for restorative justice?
There are many different support structures within the court system nowadays. Various people who have an Aboriginal background or who have a mental health challenge or who have a drug addiction, all have various supports within the differing court houses. I'm in the Toronto courthouse, but whether you're in Waterloo or in Ottawa, all of them have varying degrees of different kinds of supports like that. When the Crown is looking at a case, we will certainly take into consideration those specialty courts, as we call them, and also all other kinds of options for diversion. When we're considering the diversion, we are guided by our manual, which gives us presumptively eligible matters we can divert people on, shoplifting, things like that. Presumably ineligible things we cannot divert people on, murder, and then a class in the middle where maybe we could, maybe we couldn't divert it. Maybe we need to get approval, maybe we need to talk to a superior, etc. As part of that decision, whether it's a presumptively admissible case, a divertible case, or one in the middle, we're going to look at the facts. What actually happened in this case? What about this defendant? Do they have a history of doing this type of crime or any type of crime? What is the risk in the future of the person doing a further crime to this specific victim or another? All kinds of considerations will be taken into account. And again, the more information the Crown has, the better outcome can be determined, because we're not working in a void.
So we have a specific question in regards to long-term care home and a peace bond. What if the peace bond against someone who visits a senior within long-term care? Does the notice get put on the front door of the long-term care building?
The peace bond is generally given to the defendant. That is the first and primary person to whom the peace bond is given. The police should also get a copy of the peace bond, and it should be uploaded to their computer system. That's it, generally speaking. So if you want the long-term care facility to know about this peace bond, give them a copy of the peace bond. Sadly, I hate to say it, but the communication setup is not such, to my knowledge, that there is any automatic referral to any long-term care facilities, because in fairness, the person may move, the victim may move from one long-term care facility to another. We just don't know where they are. So as a complainant, you can get a copy of the peace bond as well, and then you certainly can take it to the long-term care facility and say, look, see, this person should not be seeing my grandfather. And then it's up to the long-term care facility to help enforce that.
Excellent, Jason. So the last question for today, and we'll close out the session. Can you comment on the potential of a person with dementia who might be charged being found NCR not criminally responsible?
I'm going to back that up a little more. There are two tests that the court has to look at. One is fitness, and one is criminal responsibility. A fitness test talks about whether the person before the court, right then and there, is aware of what's happening. If they're unfit, the court can both send them off for an examination and also send them off to see if they can be made fit. Sometimes that can happen with medication, perhaps medication the person never knew they could take, or maybe they have not been taking their medication for a period of time. The court really can't deal with a person until they are fit. And so sometimes that fitness process may take 30 days, but sometimes it's a matter that it can take much longer. Once the person's fit and can address the court and be dealt with by the court, then the next stage is proving that they have done the crime. Maybe they assaulted somebody. Okay. So having the Crown prove that they assaulted the older person, the next step that the court may ask about is whether they are criminally responsible. Did they have the mental intent to cause that, or were they hallucinating at the time? And that's the NCR stage, not criminally responsible stage. And that requires medical evidence to be called. And if it is shown that the person is not criminally responsible, they are then sent off to a hospital, a secure hospital, but a hospital. And it's the hospital's job to determine at that point, or the review board, the Ontario Review Board, to determine whether or not and when the person should be released back into the community. So there are a couple stages at which a defendant's mental health must be taken into consideration. And it certainly is, the NCR certainly is a stage at which it can happen. I hope that answered the question.
That was a pretty loaded question, so that's why I gave you a couple minutes to answer it. I am noticing a couple of questions in regards to safeguarding a victim's safety. I just want to plant the seed that if you are concerned about somebody's safety, reach out to get an in-depth safety plan through your local victim services or a women's shelter. Jason, do you have any final thoughts about safety?
I think safety, it really is multifold. Most important and first of all is your safety. Remember, when you are on an aircraft, one of the announcements they say is when the oxygen mask comes down, if you're traveling with an older person or somebody needs assistance, put your mask on first. You can't help your grandma, you can't help your grandpa if you put yourself in a situation of danger. Don't do that. That's what the police are there for your protection. But then protect yourself, protect your loved one. Make sure if you're able to gather the evidence, and call the police so that they can do their job.
Wonderful closing words and thoughts. Jason, it's been a true pleasure to have you a part of our conference today. I thoroughly enjoyed our last hour and 3.5 minutes together. Thank you again. And please, if you have questions, reach out to Jason through the platform on our conference site, and have a wonderful day. Again, thank you, Jason. Thank you everyone for attending, and we'll see you back in Feed Loop for the next session. Bye, everyone.
Thanks, Laura. Appreciate being here. Very kind of you to invite me, and thank you to the ASL interpreters today.
Yeah, thanks.